Court calls the case People versus Maurice Burgin.
This is one of those courtroom moments where everything feels balanced on a knife's edge right from the opening seconds. You're not watching a trial here. You're watching a man's freedom hinge on credibility, timing, and whether the court believes change is real or just convenient. Maurice Burgins walks in already on thin ice, and Judge Simpson knows it. This isn't a clean slate situation. This is damage control after multiple positive drug tests, and that context matters. When a defendant shows up saying, "I've got a plan," the court isn't impressed by words. It's looking for proof, consistency, and accountability. And notice how fast this turns from procedural to personal. Job lined up, housing at risk, a fiancé trying to stay clean while holding the relationship together. And these are the pressure points judges weigh when deciding whether someone gets another chance or goes into custody. But here's the tension. Good intentions don't erase violations. The court is about to test whether effort without results is enough. And the biggest question hanging over this case is simple but brutal. Is this a turning point or just another delay before the same outcome?
Andrew Children appearing on behalf of the people.
What's called?
Burgin.
Burgin.
Lori Yackey, Assistant Public Defender, with and on behalf of Mr. Burgins. Could you state your name for the court?
I'm Maurice Burgins, Your Honor.
Your Honor, may we approach on this matter?
Is there really a need?
There's a lot of updates that I've been talking with Mr. Burgins about, and
Is that to the use of recreational marijuana, which he's not supposed to do, or to the cocaine? Which is the update?
Well, it concerns both, Your Honor. It concerns all of the steps that he's taking, and specifically the documentation that he went to Home Division yesterday, and we are waiting documentation, and
Documentation for what?
that he did his intake at Home Division yesterday,
As well as CMH.
as well as CMH. And he came in with a written plan in his notebook. And I can honestly say I did not even tell him to do this, but he came in with a written plan about how he's going to stay clean.
If I test him today, is he going to test clean?
Yes, sir. But I won't in 2 days. Your Honor,
What?
Your Honor, I'm not lying to you. Judge Simpson, I've done everything that I could possibly do to make sure that I can continue to stay in society.
This is where emotion floods the courtroom, and it's also where defendants often hurt themselves without realizing it. Maurice is pleading from the heart. Job starting tomorrow, treatment intakes completed, recovery coach meetings lined up. But courts don't operate on emotional sincerity alone. Judge Simpson has heard versions of this speech hundreds of times. What makes this moment compelling is that Maurice openly admits the risk. He knows he could lose his bond, his housing, and his relationship. That honesty helps, but it doesn't cancel out the timeline problem. Testing clean today doesn't negate cocaine use from days ago. Judges look for sustained compliance, not last-minute course correction. Still, this isn't defiance. This is desperation. Work and viewers should ask themselves, if someone waits until the brink of incarceration to take recovery seriously, should the court reward that effort or treat it as too little, too late? This is the emotional crossroads of the case, where empathy and enforcement collide.
I have a job. I start tomorrow at Full House Restaurant on E-Course. I went to CMH and did my intake. I also went to Home Division and spoke with Mr. Marcus, who is a recovery coach on E-Course. All these places are within a half a mile from each other, from the hotel living in now. So I'm in position to lose my room, my residence, as well as my relationship with my fiance, who's clean and clinging on by her fingernail, because I'm trying my best to do my best and change my lifestyle, sir.
What are we doing with this case?
So I do have a green sheet, Your Honor. This is a case that is from, I believe, 2022. It's a possession. And I would ask to adjourn it because I'm hoping it comes to some sort of resolution. The bottom line is Mr. Burgins knows that he needs treatment. And I've had a lot of conversations with his fiance and him, and I really do think they are very active in making sure that he gets help, stays out of trouble. He just got this job. He has the sweatshirt that he's wearing. And he's eager to prove himself. And I think he's very genuine when he says, I mean, he asked me to ask this court to let him prove himself and to show with his actions that he is following up, that he's good to his word. I did call Home Divisions this morning and verified Mr. Marcus, I'm just waiting for his email response to come through, that he did actually go to the meeting yesterday. I did verify with his fiance, who is with him, that he did that, and that he is clearly not using, he came to court to knowing that he had this bond violation, knowing what he risked in terms of his liberty, but he wanted to do the right thing, and he wanted to stand before this court to ask for the opportunity to show that he can be clean, he can be sober, he can be in the community, and he will do the right thing. He's very eager to prove himself. He has no other cases, not on probation or parole, and he has this new plan.
Recovery coach, a new plan.
Mhm.
a new
Oh, and he's
residence.
going to Little House meetings,
Yes.
multiple times per week.
I start
um,
work tomorrow, y'all. I just need an opportunity to prove to you that I can do the right thing. I know I've made some mistakes, some horrible decisions. I'm 62 years old. I'm old enough to know right from wrong. And I apologize for my shortcomings, but I'm trying to do the right thing. Y'all. I can't prove it to you from there.
I have 4 positive tests. He's been using cocaine.
This is the moment where reality slams back into the courtroom. 4 positive tests, no medical marijuana card, recent cocaine use. From a legal standpoint, Judge Simpson is absolutely grounded here. Bond conditions are not suggestions, they're court orders. And the judge's frustration isn't about addiction itself, it's about timing and trust. The court isn't saying recovery doesn't matter, it's saying recovery must start before violations pile up, not after. This is where defense arguments often fail, because effort doesn't undo documented non-compliance. The judge is signaling something important. If courts excuse violations simply because treatment starts at the last second, bond conditions lose meaning altogether. But there's nuance too. The judge doesn't shut the door completely, he leaves a conditional path open. I mean, proof of enrollment could change everything. That's not cruelty, that's accountability with a narrow window of grace. The question for viewers is tough but fair. Should judges prioritize strict enforcement to protect the system, or flexibility to support rehabilitation when someone finally shows up ready?
It almost less than a week ago, I have a positive test regarding that.
I understand.
He doesn't have a valid medical marijuana card. He's also been using marijuana or THC at least in his system. You're telling me now, the day before he's to come to court, he's now in treatment.
I started
And
yesterday.
somehow or another, I'm just supposed to say all of that's okay.
Well, Your Honor, he knows it's not okay. I think what makes him really different is he is coming, he is testing, and he is doing his best. It is obviously a struggle for him to battle his addiction, but he is not getting in trouble. He's going to meetings. He's doing the best that he can, and I think he's doing what, especially on his own initiative. I mean, I was surprised yesterday because he doesn't have his own cell phone. He shares with his fiance, and before I even talked with him, he came up with this plan himself. And I think that goes to show that he is taking the initiative to do this himself. And he is using this added accountability of testing. He knows that he's going to lose his liberty if he tests dirty one more time. I mean, he knows that. And he knew that coming into court today. And he still came in anyways, because he wanted to prove to the court that he is willing to take that chance. And he said, the court certainly will revoke my bond if I test positive again, but I'm not going to, because I'm serious, and I'm serious about recovery. And so I would ask this court for one more week, one more opportunity for Mr. Bergens to prove himself.
I can do it, Your Honor. I promise. I'll be locked up if I don't. I can't do anything from jail. I have a job now, and I want to prove to myself as well as this court.
Anyone can do for jail.
Sir,
Nothing.
I'm sorry.
I'll adjourn this out to the 28th, 2025 at 9 a.m. I don't need a response from the people. Defendant's bond is revoked.
This ruling lands hard, and it's supposed to. Bond revocation isn't a punishment for addiction, it's a response to repeated violations under court supervision. Judge Simpson makes something very clear here. Documentation matters more than promises. The door isn't slammed shut, but it's no longer wide open either. Proof of enrollment is now the only lifeline. From a legal perspective, this is a textbook balancing act. Protect the integrity of court orders while still allowing a structured opportunity for reconsideration. Emotionally, though, this is devastating. Maurice walks out knowing freedom now depends on paperwork, timing, and follow-through. And this is where viewers should pause and ask, Is this outcome fair, or is it the inevitable result of ignoring warning signs earlier? The system gave chances, but chances come with conditions.
If you send me the proof that he's enrolled, I'll reconsider the revocation of his bond. But until such time, his bond's revoked, defendant's remanded. Court calls the case, People versus David Davis.
Stephanie Cameron, on behalf of Mr. Davis.
How come Ms. Saab has your sheet? What?
She's way more efficient than I am, Your Honor.
What?
She's way more efficient than I am.
Oh, I know. I was so happy to see her today.
I know. Your Honor, in this particular matter, we are simply, I'm sorry. He threw me. We are simply
What?
requesting a
What do you mean
two-week
I threw
adjournment
you?
because he was sitting here just as patient doing this thing that he does like this, staring at me.
Ooh.
Mr.
Okay,
Allen.
so first of all, do not flatter yourself. He wasn't staring at you.
He was.
All right, now. That's the first.
With expectation that I hand over the green sheet, Your Honor.
Oh, okay, whatever.
So, Your Honor, we're simply asking for a two-week adjournment in this matter for possible plea negotiations.
Sir, your name?
David Davis.
Thank you. How long did you need?
We're just asking for 2 weeks. Or I understand the court is not available in 2 weeks potentially, so at the court's earliest convenience.
Stop it.
You see how we do it?
September 4th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Thank you. Court calls the case, People versus, is it Eric Davis?
Alexander on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Davis. State your name.
Eric Davis. Eric Davis.
Thank you.
Your Honor, I have a green sheet for the court. We are requesting an adjournment to, so I can review discovery with my client.
Probable cause conference, September 4th, 2025, 9 a.m. Bond continued.
What we see with David Davis is the quieter, procedural side of criminal court. And it's just as important. No emotional speeches, no dramatic confrontations, just scheduling, negotiations, and efficiency. This is how most cases actually move through the system. Adjournments allow attorneys to negotiate pleas, review evidence, and resolve cases without trials. Judge Simpson's tone shifts here, lighter, efficient, almost conversational, because there's no immediate crisis. And that contrast matters. Courtrooms aren't always explosive. Sometimes justice is administrative. The key takeaway is that cooperation, preparedness, and compliance often keep defendants out of trouble while cases progress. It's not flashy, but it's effective. And it raises a question for viewers. How many defendants end up worse off simply because they don't handle the basics the way this case does?
Thank you, Your Honor.
Thank you. Court calls the case, People versus Glenn Pennington.
Torshio Feaster, Assistant Public Defender on behalf of Mr. Pennington. Please state your name for the record, sir.
Glenn Pennington.
Thank you, sir.
Thank you, Judge. You should be in receipt of a green sheet. My understanding is that Mr. Pennington, we're waiting on some additional medical records, and he wanted me to tender some records to the prosecution in hopes of getting this matter resolved and maybe.
Okay, where are we in that process? Because sometimes medical can take a bit.
Yeah, I'd asked for about 3 weeks. Please, Judge.
Probable cause conference, give you a little bit more time than
Okay.
that. September 11th, 2025, 9 a.m. All right,
Thank you very much, Judge.
not a problem. Thank you, sir.
11th, 9 a.m. Let's call it. Okay. Thank you, Judge.
Court calls the case, People versus Ramirez Martinez.
Ramirez Martinez, who should also be appearing by Zoom.
He's here.
Thank you. Mr. Ramirez Martinez, can you please state your name for the record?
Ever Ramirez Martinez.
I have before me a plea form that indicates he's going to be pleading guilty to the charge of reckless driving. Upon that successful plea, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct.
Yes, Your Honor.
All right, sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the true self you got?
Yes, sir.
State your name for the record.
Ever Ramirez Martinez?
All right. Sir, it is this court, you can put your hand down. Sir, it is this court understanding that you are going to be pleading guilty to the charge of reckless driving. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, sir.
You also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty?
This plea colloquy is one of the most legally important moments in the entire docket. Judge Simpson meticulously confirms that Ever Ramirez Martinez understands every right he's giving up: trial, appeal, coercion protections, because guilty pleas must be knowing, voluntary, and intelligent. This isn't formality for show, it's constitutional protection. The reckless driving charge carries real consequences, but notice the benefit: count 1 is dismissed. That's the trade-off of plea agreements. The judge also warns about misconduct before sentencing, a critical reminder that even after pleading guilty, defendants can still derail their outcome. This exchange is calm, structured, and precise, showing how the justice system functions when everyone follows the rules. No theatrics, just accountability. And the audience should consider this. Is a negotiated plea justice served efficiently, or justice compromised for speed?
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yeah, I think,
Oh, you went through an advice of rights form with your attorney
yes.
and gave your permission for them to sign?
Yes, sir.
And you understand all of those rights?
Yes, sir.
You understand that you're giving up those rights, and particularly the rights that are contained in paragraph 5, your trial rights.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
On the date of June 1st, 2025, at the location of East Michigan Avenue near Campbell Avenue in Ypsilanti Township, Washtenaw County, State of Michigan, were you driving a motor vehicle?
Yes, sir.
In what manner were you driving that motor vehicle that makes you think that you're guilty of the offense of reckless driving?
I was just driving recklessly. I was going above the speed limit. I failed to,
How far above the speed limit?
I think it was 71 and a 50.
You were doing, so you were about 21 over,
Yes, sir.
and that was on Michigan Avenue?
Yes, sir.
And were you operating that motor vehicle in a manner which you would consider a wanton disregard for property and or persons?
Could you repeat the question again?
Were you operating that motor vehicle in a wanton, meaning that you really weren't of much really caring or concerned about property and or persons?
Yes, sir.
All right. Sir, if I do accept your plea, you do understand that if you commit misconduct between the time of my acceptance of the plea and the time of your sentencing, that the judge would not be bound by any type of sentence evaluation and or agreement, and that you would not be permitted to withdraw your plea. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
People satisfied, Your Honor.
Been satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
September 25th at 10 a.m.
September 25th, 2025, 10 a.m. before Judge Washington. Bond will continue. Thank you, sir.
Your Honor.
Thank you.
This is a clean example of how a case is supposed to conclude at the plea stage. Judge Simpson confirms compliance with court rules, accepts the plea, dismisses the remaining count, and orders a presentence investigation. That report will now guide sentencing before Judge Washington, not this court. This distinction matters. Defendants often assume the judge taking the plea controls the final outcome, but sentencing authority can shift depending on jurisdiction. Bond continuing here is significant. It signals trust. No immediate risk, no pattern of violations, no reason to remand. Compare this outcome to Maurice Bergen's earlier, and the difference becomes crystal clear. Compliance, timing, and credibility shape results. Same courtroom, same judge, completely different consequences. This contrast reinforces a core truth of criminal court. Outcomes aren't about emotion, they're about consistency and risk management. Viewers should ask themselves, how often do people misunderstand what really earns leniency in court?
Court calls the case People versus Marina Sexton.
And then on behalf of people, Your Honor. Good morning, Your Honor. Assistant Public Defender, fellow Casey McGee, seeking permission to practice.
Who?
Casey.
No, go ahead. I'm sorry.
Seeking permission to practice pursuant to Michigan Supreme Court Rule 8.120 under
Michigan what?
8.120.
Michigan, what kind of rule?
Michigan
Who
Supreme.
gave you? You're okay. Don't worry about it. Who told you what to say?
The Supreme Court of Michigan
Personally?
by order. Court order.
All right, go ahead, because you're gonna have to do this again because you're not giving me the right words.
Okay. Assistant Public Defender, fellow Casey McGee, seeking permission to practice pursuant to Michigan Supreme Court Rule.
Just court rule.
And
This
Okay.
gets hard.
Michigan Court Rule 8.120, under the supervision of Assistant Public Defender Saab. On behalf of Ms. Sexton, who is standing to my right, Ms. Sexton, please state your name for the record.
Have you appeared before me before? Probably not, because you would have had it right. But
Okay,
where are you from?
I'm from Detroit.
From Detroit.
Yes.
Born and raised in Michigan?
I was, in Michigan. I was born in Muskegon. I moved to Detroit.
Okay, that's still in Michigan. And then you came to Detroit. So you're a Michigander.
Mhm.
Okay, then I'll forgive all that. You're good.
Thank you.
All right, permission to practice is granted.
This moment adds levity, but it also reveals something important about courtroom culture. Judge Simpson's exchange with the young public defender fellow isn't just humor, it's a stress test of preparation. Courts expect attorneys, even new ones, to know the rules they're invoking. Michigan Court Rule 8.120 allows supervised practice, but the judge makes it clear, precision matters. At the same time, the judge balances authority with mentorship, granting permission while signaling expectations. This interaction shows viewers that courtrooms aren't hostile environments by default. They're professional spaces where competence earns respect. It's also a reminder that credibility applies to lawyers just as much as defendants. The tone here resets the room after heavier cases, proving that not every moment is adversarial. Yeah, but every moment still counts.
Where are you in
Thank
school?
you.
Oh, you're
I
grad school.
graduated. I just took the bar exam.
Ow.
Right. Exactly.
Where'd you graduate from?
University of Toledo.
All right. So you went to disputed territories. All right.
Unfortunately,
Yes, I know.
Yes, Your Honor.
It's okay. All right. And ma'am, what is your name now that we've been ignoring you, right?
I'm Marina Sexton.
Thank you. All right, what are we doing on this case?
This morning, we would ask for an adjournment. Discovery is incomplete in this matter, as far as I know. We sent an email yesterday afternoon.
Okay. And you're seeking an adjournment of these proceedings. Got it. Probable cause conference will be adjourned September 11th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank you.
Court calls case People versus Christopher Smith.
Christopher Smith.
Okay.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Smith. Your Honor, we are asking for an adjournment. We are waiting to receive and review video discovery.
Got it. Probable cause conference will be adjourned September 11th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Court calls the case, People versus Raymond Strausser.
An assistant public defender, Hannah Apple, appearing on behalf of Mr. Strausser. Now. Your Honor, I apologize. I have, Mr. Strausser, will you state your name for the record?
Raymond Charles Strasser.
Thank you. I have not had an opportunity to talk with Mr. Strausser. We did not have a phone number in the file, and I emailed twice yesterday. If the court, I know that there's a bond violation report I received yesterday.
Well,
If I could have a chance
and
to.
I got that today.
You to report to.
Well, this is part of the problem with JIS.
They never said nothing about that. Well, I got.
Nobody had any information for him and nobody had a way to get in touch with him, including community corrections. So while this is a violation report, I usually prefer them to try to have contact prior to finding some violation. So here's what I'm going to do. Mr. Strausser?
Yes, sir.
All right. So I'm going to adjourn, find good cause. I'm going to adjourn your probable cause conference to September 11th, 2025 at 9 a.m.
I'm supposed to go in for rehab treatment on Thursday. I've been selected
When?
at the VA hospital.
So you're a veteran?
Yes, sir.
What branch?
Army.
Army? Okay, I'll forgive you.
Okay, thank you.
No. I'm a Navy kid, so that's why. Just listen. So what we'll do, you're supposed to go in.
An inpatient treatment? What kind of
Inpatient
treatment?
or out?
Inpatient.
An inpatient.
Yes, sir.
Okay.
Yes, sir.
And that's coming up Thursday.
I'm going in for my intake on Thursday where they test me and everything else
Okay,
at the Ann Arbor VA. And then I'm
Gotcha.
supposed to be on my way out to Battle Creek,
got it.
where I'll probably spend about a year.
Okay, so you're just gonna go into that. So I'll still adjourn it out to that. date.
Okay.
Just
Should
11th.
he,
Okay, go ahead.
should he report to community corrections now? Or how would the court like to go about that if he's gonna be in treatment with the VA?
Yeah, well, why don't, because this is sitting with a violation report. So yes, I'll need a new order. What I'll do is, I need you to report to community corrections. They're right here on this facility, okay?
Okay.
And then if you go into treatment, they need to know so that they won't be sending a violation report to me. Does that make sense to you?
Yes, sir.
Okay. So
I'll talk
let's,
him through all that.
okay, let's do that. And so I'll adjourn it to the 11th. His bond will continue. And while I was joking with you, sir, thank you very much for your service.
You're welcome.
This exchange with Raymond Strausser brings humanity back into focus. The judge acknowledges military service, but he doesn't exempt the defendant from responsibility. Instead, he integrates treatment, supervision, and reporting into a structured plan. That's problem-solving justice in action. Veterans courts and VA treatment pathways exist because service-related trauma often intersects with substance use and legal issues. Judge Simpson ensures community corrections stays informed to prevent unnecessary violations while treatment proceeds. This is not favoritism, it's tailored accountability. The judge maintains bond, requires reporting, and sets clear expectations. Respect doesn't replace rules, it coexists with them. Viewers should consider this carefully. Should courts adapt their approach based on background when it improves outcomes, or should every case be treated identically regardless of circumstance?
I'll tell you, I get to do what I get to do every day because of people like you that did what you did.
Well,
Right?
it's
And I
been
do appreciate it.
it's been entertaining while I've been here today.
Well, thank you, sir.
You have a blessed day, sir.
You do the same. The court does call the case of the People versus Khalil Taylor Jefferson.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Chelsea Virgils with and on behalf of Khalil Taylor Jefferson. Please state your name.
Taylor Jefferson.
Your Honor, we are asking to adjourn this case. There's a
So
potential.
that he can get real pants on.
We'll work on that as well.
Okay, thank you.
He is interested in felony drug court. We just want to discuss the circumstances a little bit more.
During this matter, September 4th, 2025, 9 a.m. Bond continued.
Your Honor.
Thank you. Court calls case People versus Keandre Vaughn.
Joseph Gonzalez on behalf of the people, Your Honor.
Assistant Public Defender Chelsea Vergils with and on behalf of Keandre Vaughn. Mr. Vaughn, please state your name.
Keandre Vaughn.
All right, I see your request. So what I will do is I'll adjourn probable cause in this matter September 11th. Give you time to get some of that done. 9 a.m. Bond continued.
Thank you.
Thank you.
Today's docket shows the justice system in full motion. Mercy, discipline, structure, and consequence all sharing the same courtroom. Judge Simpson applies the same legal framework to every defendant, but outcomes diverge based on behavior, timing, and credibility. Maurice Bergens learns that effort without sustained compliance isn't enough. Others benefit from preparation, cooperation, and procedural patience. This isn't randomness. It's accountability playing out in real time. Court isn't about who tells the most emotional story. It's about who follows through when no one is watching. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.